Good afternoon, everyone, and welcome back to Personal Wealth Strategies for our next installment of our webinar series. Today, we're honored to have with us Gary Garland, who's going to speak about estate planning and elder law for yourself and your elders. But before I introduce Gary, I do want to make everyone aware of the fact that we'll be having upcoming webinars each month on the second Wednesday of the month, and I'll go over the schedule at the end. I also posted on our website. Before I do introduce Gary, I want to introduce one of our newest financial advisors, and that will be Ed Schuler. Ed has been in the business for 26 years and has recently joined our firm. Ed's going to be opening up an office in the Toms River area, and will be working with clients in small to mid-sized companies, along with numerous associations, physicians, and dentists. I've known Ed for a number of years, and he's a welcome addition to our family. And with that, let me turn the mic over to Ed and let him introduce Gary.
Thanks, David. Again, my name's Ed Schuler. Thanks for coming and listening to our presentation today. The presentation is, again, regarding elder care and estate planning. Gary Garland is the attorney who's going to be giving the presentation. He's a certified elder care attorney. He's been practicing for about 24 years. He does work out of Manalapan, does plan on moving to or having some exposure in Toms River as well too, in the Hamilton area. He is certified in New Jersey, New York, Staten Island. Are you certified in Florida as well too?
No.
Okay. So with that being said, I am going to pass the mic on over to Gary, let him start his presentation, and have a great day. Hopefully you'll listen to some of the presentations we have. Go ahead, Gary.
Gentlemen, thank you so much for having me here. It's an honor and a privilege. The challenge to the audience is, how do I present material that will, it's dry material in general, so how do I present it in a way that's not talking over you or under you, and in a way that's of interest? I probably can't, so I'll just encourage you to please listen along. Maybe you'll grab some kernels out of this that'll be useful to you. If nothing else, you'll have some cocktail conversation. And if you don't like it, then you know to avoid me in Manalapan, Toms River, Staten Island, and Manhattan. Alternatively, and Hamilton. But alternatively, let's get running. We have about 45 minutes. I have 49 slides, so if we do the math, I was a math major, but I'm pretty sure we don't have 10 minutes a slide. So let's just get moving. All right, we're in New York, we're in New Jersey. Next slide. All right, so let's talk about the difference between estate planning and elder law. Generally, with estate planning, we're looking to avoid estate taxes, getting things down to the next generation. With elder law, on the other hand, there's a wide umbrella. Some of it is, a large focus of my practice is Medicaid planning and protection. Medicaid is a huge benefit that people don't realize they may be entitled to. One of the things that we often do is Medicaid for millionaires. Elder law can also include age discrimination, adults with disabilities and whatnot. For our purposes today, I think it makes sense to stick with the Medicaid arena, which is what most people come to us for. For you, you'll make sure that you're protected, and for your family or elder, you'll be sensitized to the issues that they may be facing or that you've seen before. A small case study I'd like to show you, and if we have time, we'll go over it at the end, is we have Fred and Wilma. And Fred is 80 and Wilma is 79, and if you have the slide in front of you, then you can read it as well as I can. But the upshot is, they have $1 million, they have some income, he lives at home, and what are some options? What you may or may not consider is that since he served in the military, we may have veterans benefits available to us. That is a found benefit that the VA does not tell you about. For a widow, it can be worth $11.49 a month. For a veteran, it can be $17.89 a month. For the couple, it's over $2,000 a month. Found money. We have $1 million. For those of you who are thinking of Medicaid, I will tell you, if you have $1 million, you probably have a little bit too much for Medicaid, by about $998,000. So there are some things to consider. How would we potentially get Medicaid with $1 million? And that's some of the things that we'll touch on. Now, if Fred passed away and Wilma has $100,000 in assets, so we lost $900,000 in care or whatnot, one thing to consider is that, and we're going to touch this later, a married couple has different Medicaid rules than an individual. With a married couple, we can shelter more assets than an individual. And if we've lost our healthy spouse, well, now we have extra assets to deal with. I threw at the bottom of this slide, what if she gave away $50,000 2 years ago? Because most people are aware that Medicaid looks back 5 years. And if you're not aware of it, again, we'll talk about it in a little bit. So I wanted to give this to you as a little bit of a warm-up so that you can see some of the things that are out there. Again, we have some more case studies. I'd rather get right to the meat. So one of the questions or concerns that we have in the elder law arena is, who is the client? Is it the family in front of us who are retaining us and telling us about the elder, or is it the elder themselves who we may possibly not have met? Generally, it is going to be the elder. So although the daughter may come to me with a power of attorney and a checkbook, and in that case I have great loyalty to the daughter, but the true loyalty of the client is the elder, who I may not have met and who may not even be competent. We run into real issues if a daughter or a son comes to us and says, my dad wants everything to go to me, nothing to my 12 siblings, and he's incompetent. We run into real issues there. So anyway, what are we concerned about when there's somebody across the table? Are we looking to protect assets and transfer them for wealth purposes, avoiding taxes? Well, then again, we're back in the estate planning arena. If we're looking for long-term care costs, how we're going to pay for it, where we're going to do it, now we're in the elder law arena. And we have some families that walk that tightrope and can be a little of each. Right. Everybody needs foundational estate planning regardless of the asset amount. And that means a will, living will, healthcare power of attorney, financial power of attorney, and privacy authorizations. Now, we're speaking to folks in New Jersey. This thing, Ed was asking me about Florida. I'm not licensed in Florida. I just kind of play it on TV, and I have a lot of family there. So New Jersey, New York, and 16 other states have decoupled from the federal government. What does that mean in English? This year, federally, you could leave $5.43 million without a federal estate tax. Sounds pretty good. Double that for a couple, 10.8, it's at 10.86. But in New Jersey, we have an estate tax that starts at, drum roll, $675,000. So that means if we have an individual with $1 million who is single, well, we have less than 5.43, so there's no federal tax, but we have a New Jersey tax that starts at $675. So on $1 million, we have an estate tax of $33,200. And people are getting tripped up by that because they hear it's $5 million, they think it's $3 million. Whatever the number they think it is, they're not being aware of the New Jersey 675. If you're married, you can double it, and it's 1.35. So that's something we need to be aware of. Other things to be aware of is cost basis versus the estate tax. By the way, I'm from New York. If you want me to speak a little faster, I guess call in or something. So anyway, when we buy something, we have a cost basis. We buy a share of IBM stock for $10. And if we want to give it away, we pay $10, which means that they paid $10, the recipient, the donee. So if I give away a share of IBM stock that costs $10 and now it's worth $110, if I give it away or if I sell it during my lifetime, there is a capital gains tax on the sale. If I leave the asset to the person upon my death, they get what's called a step up in basis. I don't care what I paid for it. I care that it's worth $110 on my date of death, and my beneficiary gets it at $110. What does that mean? If they sell it for $110, there is no capital gains tax. However, that $110 is subject to an estate tax, whether one is owed or not. So if the state is able to charge you, or the feds can charge you an estate tax, whether one is due or not, you get your step up in basis. If I've given away that stock during my lifetime such that it's not subject to my estate upon my death, then there is no step up in basis. And that's the difference between a completed gift and an incomplete gift. And we juggle around with that depending upon the characteristics of the asset and what we want to have happen. Moving right along, we have foundational documents. They include, like I said, wills, living wills, healthcare powers of attorney, financial powers of attorney, and privacy authorizations. Wills versus trusts. We can talk all day on these things, but I just want to give you the meat of the subject. So when we have a trust, we have revocable trusts and we have irrevocable trusts. There are about 65 different types of trusts with different characteristics and persons. With a revocable trust, the person who's creating it, called the grantor, the trust maker, or the settlor, it can be in charge of that trust. With an irrevocable trust, we will generally get those assets as far away from them as possible. Why do we want to do that? Maybe we want Medicaid protected trusts or veterans benefits protected trusts, or we want to have life insurance protected trusts, or we want to get things out of the estate. With a revocable trust, we're maintaining control, and we're avoiding certain tax issues that come up in New Jersey, like tax waivers and so forth. So there are advantages to each type of trust, and you need to use the right one in the right circumstance. When we have distributions, whether in a will or a trust, we can have an outright distribution, which means everything goes out in one shot, no strings attached, or we can have trusts where there are strings attached. There's restrictions on the distributions, and by doing that, maybe we'll leave money to a minor over a period of time so the money doesn't get squandered out of the gate. Or we might put things on like an incentive, get a job and we'll match your earnings by 10% or double it or whatever the case would be. Or we can do a sprinkling trust and we'll give you money every year or 2 years or 5 years. So we can do all sorts of different things. The grantor is, I said, the creator of the trust. We can have trusts that are revocable or irrevocable that are grantor trusts or non-grantor trusts. With a grantor trust, we can have the income tax paid for by the grantor even if it's an irrevocable trust. So in some families, I tell them, I'm giving you the worst of all worlds. I'm holding you responsible for the tax, but I'm taking things away from you and you have no control of the asset. But we'll have lower tax treatment. With a non-grantor trust, we can have the trust pay the taxes on any growth, or we can have the taxes passed through to the beneficiaries. With wills, a simple will is generally an I love you will, everything to my spouse, the rest to my kids. With a complex will, we will have some tax planning within there, and then we may also have various trust fund distributions to the beneficiaries. We already spoke about estate included and estate excluded. Let's talk about some estate planning mistakes. This is the Honeymooners, for those of you who don't like Fred and Wilma. And if you didn't know, the Flintstones were based on the Honeymooners. But I haven't checked Snopes lately, so I could be wrong on that, but I'm pretty sure I'm right. If you look at the bottom photo, you'll see Jackie Gleason, the great one. This is probably the thinnest that he ever looked because I had to compress the image to get it to fit on the slide. So he was the great one. He was also a little bit of a big one. That one's a flattering photo, I would say. So here we go. Here's an estate planning mistake. So where we should have used a trust is a big one. What if we were leaving something outright to somebody and they squander it? But here's another one. What happens when the assets are not coordinated with the legal documents? For example, there's a deed and it says Ralph and Alice. And Ralph dies, Alice is the survivor, and his will says his part of the house, or his will says the house goes to Trixie. Uh-oh, who gets the house? Well, we have a situation. First of all, if Ralph was alive, Alice would kill him for leaving things to Trixie because maybe there's something going on there, but that's a whole other conversation. It's a different program. So anyway, the deed says Ralph and Alice, and Ralph dies. His will says the house goes to Trixie. When I give this seminar, generally half the room thinks it goes to Trixie, half thinks it goes to Alice, and the other half, which is the third half, they're asleep anyway. So what really happens? If Ralph dies first, and Ralph and Alice are on the deed as husband and wife, in New Jersey, when you buy property as husband and wife, it's a form of joint tenancy, but it's actually tenants by the entirety. Regardless, the survivor gets the asset, the house. So Ralph's will is nullified regarding the house. He says it goes to Trixie. It really doesn't. It goes to Alice, who is the survivor. Now, on the other hand, if Alice predeceased Ralph, then absolutely, his portion of the house then goes to Trixie. And if Alice predeceased, he would have had the whole house. All right, so we see Ralph intended his girlfriend, Trixie, to get the property, but his wife ended up with it. So his assets did not coordinate with his legal documents, and the legal documents were wrong as far as this goes. Other assets that may have to coordinate include IRAs, life insurance policies, joint accounts, anything with a non-single owner. Let's do it again. If Ralph has an asset in his own name and he dies and there's no beneficiary, it's a probate asset and it goes through the will. But if Ralph has a joint owner on it, then it passes by operation of law. And lastly, of course, after Trixie finds out about this, and Alice finds out, does she run off with Ed? So, I can't answer you. Moving right along. If we leave things to a minor, that's a bad thing. Industry statistics show outright distributions typically squandered within 18 months. And I always say Paris Hilton could do it faster. If we leave too much too soon. So instead of leaving everything to the 18-year-old who's not a minor, maybe we should have left to the 21-year-old 3 years later. Or maybe we should spread it out over a period of time so he or she doesn't have fair weather friends and blow through the inheritance, as other people have told me throughout the years, when we don't consider the actual values. So you come to Ed, he writes you some nice life insurance, it does some planning for you, and your portfolio grows. And without thinking about it, you have $1 million or better, and you have a young baby. And your will says, I leave everything to my spouse, If my spouse is gone, it goes to my child. And if you're lucky, maybe you said age 18. If you're not lucky, you just said to my child. It would be better if you left it to the child over the years. Sometimes I have folks who have a will done by a real estate attorney at the closing, and the attorney puts in there 1/3 at 18 and maybe half at 21 and the balance at 25. So if we have $1 million, whether it's life insurance or assets, and we're leaving 1/3 to that 18-year-old, that's $333,000. People don't think about these numbers. And some life insurance policies are very cheap. You can buy millions of dollars of coverage. So you might leave $2-3 million to a beneficiary who just can't handle it. And that's a case of not considering the actual values. Similarly, you might think you have X dollars, and as time goes on, maybe you've spent some of it and your values aren't what you think they are. So you want to be aware of that. We also need the fiduciaries, the executors, the trustees. We want backups. Redundancy is good. I generally like to go 3 deep. It's a biblical number, gives me some redundancy. If I name my sister and brother-in-law as a backup, it sounds like 2 people, but in a lot of instances that's 1 unit, because God forbid we can lose them both in the airplane or the car accident. So I like to go 3 deep, where it's really 3 safe individual successor fiduciaries. All right, same thing with beneficiaries, by the way. You need backups there as well. We talked about not coordinating assets. You got to review your estate planning documents and your financial circumstances. I'm not the financial advisor. I'm just the law guy. So if I do a beautiful document, but you don't have anything to put into it, that didn't work either. So I say you should review every 3 years of major life changes. Maybe that's not even enough, but that's something to at least consider. All right, if you have a spouse, again, very often we see the I love you wills, everything to my spouse and the rest to my kids. What if that spouse is on Medicaid or likely to need Medicaid? So then we don't want to leave everything to them. In fact, we want to leave them as little as possible. But we'll move on. All right. With the ancillary documents like the power of attorney, if you don't have a financial power of attorney, it can be bad. If we have Ralph and Alice on the deed and Ralph is incompetent and we need to sell that house, if Ralph died, Alice would inherit the house and be able to do what she wants. But if Ralph is alive and he is not competent and doesn't even know what a house is, then we got a real problem. So what do? If we have a power of attorney and it's properly structured and it survives in capacity, then Alice can do what she needs to do with the house. If we don't have a power of attorney and Ralph is not competent, we're going to court for a guardianship proceeding. The difference between guardianship and a power of attorney is that a power of attorney, you're giving somebody permission. With a guardianship, the court is taking away their ability to act. Moving right along. Healthcare documents. You need these things: living will, healthcare power of attorney, HIPAA authorizations. HIPAA's Privacy, Health Insurance Portability and Accountability Act. So who can find out from the doctors or hospital how you're doing? Living wills. We all may remember Terry Schiavo from a few years ago, and she was in the news, and the big issue was, did she want to survive in a permanent vegetative brain dead state, or, did she want to be let gone? Her husband said, let her go, she didn't want to live this way. Her family said she did want to live. And the husband said, no, she really didn't. And by the way, she has a big insurance policy around the beneficiary. Well, ultimately, the court did pull the plug. But we, at the elder law bar at the time, would say, don't be in the newspaper. Have a living will, and this way at least people know what your wishes are. A DNR is a do not resuscitate. A lawyer cannot execute one of these. You Google it. If you're old enough, you call it the Google. But if you're listening on YouTube, and I think Google owns YouTube anyway, it's just plain old Google. Forget the. So anyway, you can Google NJDNR, download the form, have the doctor sign it, put it all over the house, on your forehead, on the refrigerator. You put it where the ambulance personnel see it, and then they will not resuscitate if you're in cardiac arrest. POLST is another one that's new. It's about 1 year, 2 years old now. It's a green form. I think I have it on one of the slides coming up. Practitioner's order for life-sustaining treatment. It's almost like a super living will that is a practitioner's order, a doctor's order, or a nurse practitioner. So that's something you may want to consider for end-of-life decisions. Lastly, I see this a lot, where someone names their son and their daughter as the healthcare agent. The statute says that's no good, but the other thing is, what if the doctor says, in a soap opera question type of way, do we cut off the leg and save their life, or do we leave the leg but there's a real chance of gangrene and death? And the son says, mom or dad would never want to live without the leg, and the daughter says, no, we got to give them the best chance for survival. And so one says go left and one says go right, and the doctor says the door's in the middle, go out. You need one agent at a time, one figurehead. They can talk to each other, but you need one. Here's the POLST document. You can all see that, moving right along. Now you just Google it, but this is like a super living will. And it's that, I call it Hulk green color, so this way it sticks out in the medical charts. And if you print it on black and white, it's fine, but green would be better. We talked about the 675 New Jersey estate tax exemption. On a $5 million estate, you're looking at $391 in New Jersey taxes. 5.25 would be $429, and beyond that, I don't have it memorized. And that number is going to change every year. You got to plan for the New Jersey estate tax. You got to know about the inheritance tax. So as we say on the bottom of this screen, Class A is inheritance tax exempt. That's a son or a daughter or a parent or a grandparent, so straight up or down the family tree. Class B was repealed. Class C is when we go sideways a little bit. Sibling, son-in-law, daughter-in-law. Class D is everybody else. To round it out, Class E are charities and also the state. No inheritance taxes due on Class E, but if you have anybody except a Class A beneficiary, then you have to file an inheritance tax. And if your estate is more than 675 to a non-spouse, you're looking at an estate tax. And for good luck, if you leave $1 million to a niece, you're looking at an estate tax and an inheritance tax. If you leave $1 million just to a son or a daughter, you're looking at an estate tax. If you leave $300,000 to a niece or a nephew, there's no estate tax, but there is an inheritance tax. I don't know about you, Ed. I'm finding all this kind of taxing. And the jokes don't get better, folks. Weddings and bar mitzvahs. Moving right along. So if we have to file an estate tax return or an inheritance tax return, the state of New Jersey has this little cute thing where they get a noose around your neck. And they will release 50% of the account value and lock up the other 50% for roughly 2 to 4 years. You need something called a tax waiver. When we don't have this circumstance, less than 675, no non-Class A beneficiaries, we can do an L8, which is for personal property, or an L9, which is for real estate, and that allows the release of the held-up funds. But if you can't do that, then you need the State of New Jersey Division of Taxation to then send us something that ultimately says the tax has been paid and you're allowed to take the full balance remaining in account number 123. And the problem is, a year into it, you forgot about account 4, 5, 6, or you didn't know about it. Now you have to amend the return, send it back in, get a new waiver. So living trusts will avoid that, and there are other things that we can do. Life insurance is a big one also. Life insurance also avoids the Class C and D beneficiary issue. All right, moving right along. Life insurance, hey, well, we haven't talked about that in a while. So life insurance is usually income tax free. You got to be careful when you're involved with a business, but for individuals, it's income tax free, but it is not estate tax free. So what do we mean by that? If we had stock and we put $10 in and it's worth $110, we have a $100 capital gain. What if we have an insurance policy, we pay $1,000 a year premiums, we pay them for 5 years and then we pass away, and the thing pays off $1 million? Well, I put $5,000 in, I just got a $995,000 gain, but it's not taxed as a capital gain. So we've avoided income tax and capital gains taxes, but we did not avoid the estate tax. Now, if we had something called an irrevocable life insurance trust, then we can get that out of the insured's estate and avoid the estate tax. Now, who do we want as a beneficiary? Do we want our son or our daughter or our grandchildren, and what percentages and what kind of payouts? The insurance companies aren't going to do crazy payouts. That's where we might do a trust so we can get it out of the estate, and we can also have control of how things are paid out. Who is the beneficiary? Well, if it's your ex-wife, the old law used to be that your ex-wife would get the money and your current wife would get the estate tax bill because the money went to a non-spouse. The laws changed in New Jersey, so divorce basically automatically kills them, and that may be really beneficial if you want to kill them anyway. But they're treated as if they're dead for beneficiary designations and insurance, but you need to be aware of that. And similarly, if you actually do want your ex to get, you need to do things to make sure that they do receive. All right, so we want to consider life insurance trusts because they really help us out with life insurance. Forms of ownership. So I talked very briefly about tenants by the entirety with Ralph and Alice when you own a house and you buy it as a married couple. If you bought the house if you bought the house before you were married, I should say, you buy the house and then you move into it after the wedding, the house is not tenants by the entirety, but it can still be joint tenancy. You can have something called tenants in common where it then goes to each individual decedent. There's different ways to own assets. Moving right along. Personal property. This is where I see a lot of fights in the estate litigation side of our practice. So I had one brother and sister ready to kill each other. And the one thing they didn't fight about, it amazed me, was Dad's watch. The son wanted Dad's cheap, everyday watch, and the daughter wanted the expensive watch, which she then pawned off. She really did. Anyway, the son wanted the everyday garbage watch. The daughter wanted the good watch for the money. That was the one thing they agreed on. They didn't agree on anything else, though. But if we have 3 boys, who gets Dad's everyday watch? Other big arguments are over mom's engagement ring, wedding band, and if she's a black widow, who gets all those rings? Dishes, fine china, silver, jewelry, dad's hobby items. That's where I see the fights. I don't see the fights over the bank accounts because the bank accounts are joint and we deal, well, we can run into that as well, but generally it's these types of things that we see the fights about. So we can do something called a personal property memorandum, get it out on paper, make it clear, and this way you might be a little insulted, Ed, you didn't get the everyday watch you wanted, but at least you know this is what mom or dad wanted. Moving right along. Elder law, all right? So congratulations, you're still awake. I thought I heard a cricket. You're still awake out there, I hope. And we talked about the estate planning kind of rapidly. And when we say we talked about it, it was really me. You were stuck listening. Well, here's a little bit on Medicaid. Medicaid, the big M. So we spoke very briefly that there's different requirements for an individual versus a married couple. An individual needs to be down below $2,000. If we have a married couple, the individual is now the IS, institutionalized spouse, who still needs to be down below $2,000. The New Jersey law changed favorably, believe it or not, December 1 of 14. Before then, we could have a little bit more of income. Now, different things took place, but we can't have more than $2,000 in assets. As far as income, before December 1, we were limited. Now we can do things called a Miller Trust, and what that does is it lets us shelter additional income. So as far as Medicaid goes, for the most part, don't worry about excessive income. In fact, the problem is we have generally too little income. When we have a married couple, we have the community spouse, and the community spouse is the one not seeking Medicaid. And the community spouse is able to keep about $119,000 in assets. They're also able to keep the home up to about $828,000 or so in equity, and that changes every year. They can keep a car and so forth. And some of the things that we do is, how do we shift assets around or shelter them? We never hide assets. The difference, I have a program I do where I have a slide, and it asks about the difference between tax avoidance and tax evasion, and the answer is 20 years. Similarly, we do not hide from Medicaid because, Ed, you're wearing stripes, you look good. I don't look as good in stripes as you, so I don't want to wear those thick stripes. We let Medicaid know everything we've done, and then we thumb our nose up at them, but we let them know what we've done. Veterans benefits are a win-win. With Medicaid, people don't like the idea of getting poor, and they don't want to take it sometimes. I say take it. But regardless of that, some facilities don't want you to go on Medicaid, or they prefer you don't go on Medicaid because they get paid more when you pay out of your pocket than they get from the government. But too bad. If they accept Medicaid, they're required to. People ask if the level of care changes. I say not at all. You get the same lousy level of care you got before on private pay. But regardless of that, I try to get people on Medicaid as soon as it makes sense for them to be on it, as long as they're not being hurt and they're saving assets. I'd rather the money goes to the family than it does to the government or to the facility. Veterans benefits does not hurt anybody. The veterans benefits is a reimbursement for having expenditures. So what we're looking at with veterans benefits is unreimbursed medical expenses to reduce your income for VA purposes. And very briefly, let's use an example of someone having $2,000 a month income and they have $3,000 a month for a caregiver. Their income for VA purposes would be minus $1,000 a month. When your income for VA purposes is zero or negative, you get the full benefit as long as you have the medical need. And if you have someone in there for $3,000 a month, you probably have a medical need. You're probably not just lonely, because then if you were, you just get a cat anyway. So what are we looking at? For the veteran, it's about $1,789 a month max, and that goes up every year. For a widow, it's $1,149 a month. And if the veteran is okay and the spouse is sick, we're looking at $1,406 a month. And again, these numbers go up as Social Security goes up, like 1.7%. This slide has the wartime periods. What's of real interest, there's no more World War I veterans. There could be some widows left. World War II is my big one. World War II in Korea. Get a little bit of Vietnam. And you'll notice the dates change. It expands if you were in the Republic of Vietnam. If you were not, then you have the wartime on the bottom, August 5th, 64 to May 7th of 75. If you were over in Vietnam, then for you it started up to 3 years earlier, a little over 3 years earlier. The Gulf War has not yet closed out. So I don't know what's going to happen when these Gulf War veterans from 1990, August 2nd, 90 and onward, then start applying for VA benefits. Because, I mean, we've got, I can't do the math right now, 20 years, more, 25 years going on. So that's an awful lot of veterans. So like baby boomers have been breaking a lot of things in the government. I think the Gulf War veterans are going to be doing that as well. So they're going to have to do something differently. But that's moving along. Let's talk about life care planning. So one of the things that we do, I'll pat myself on the back, is we have a social worker on staff, And that helps families when we have transitional issues, finding facilities and whatnot. So life care planning is basically helping families in an elder care setting. We also help reduce falls and Medicare readmissions. Facilities do not like Medicare readmissions because the hospitals get dinged and they lose percentages from Medicare. And we're talking significant numbers on facilities that are sometimes skating by. So it's all a good thing, just being careful. Now, let's talk about the elder care continuum, how we would like to age. I'd like to age very old, thank you. And my old joke is something like, and I've heard it, I never say it right, I want to be found, I want to die at 100 years old, in my underwear, on a window ledge, running away from my girlfriend's husband. Not really, I'm lazy, I'd rather walk, and with my luck it'll be cold. But anyway, here's what we have. We start off at home sweet home, and then as time goes on, rest in peace. And what happens in that interim? Well, we're not likely to go from the house right to the grave. I mean, you fall in the shower, or you go from independent healthy and you decline and so forth. But what's more likely to happen is we're going to have some stops on the way. So here we go. We're home. We may have to go back and forth to the hospital and the nursing home, and then ultimately rest in peace. Now, some of the things are, how do we pay for that nursing home when we're looking at $9,000, $10,000 a month? With the elder care continuum, unfortunately, we're always going from the left to the right on this slide. So we start off healthy, home sweet home. The IADLs are instrumental activities of daily living. If you speak to providers, most of them don't know what an IADL is, but they all know what ADLs are. ADLs are activities of daily living. That's what you need to trigger for long-term care insurance policies. You need to trigger that for veterans benefits. You need to trigger that for Medicaid. And if you have any interest in long-term care, I highly recommend you speak to Ed about that. When a family asks me, I recommend long-term care insurance every single time. Now, you may not want to pay for it, you may have medical issues, but if you have long-term care insurance, it makes the Medicaid planning far easier, and it also makes some of it even less relevant. With the proper long-term care insurance, you can age in the home, get a caregiver in there. If it's unsafe for you to stay home and you maybe have to go to assisted living, the long-term care insurance can pay for it. My dad's been using his policy for the last 2 or 3 years, and he feels he doesn't need a caregiver, except we feel that he does. So she's there for 12 hours a day. His policy has something like $250,000 left to it. He's 87 years old. He tells me that he thinks he doesn't have 3 more years left, but he's been saying that for 10 plus years, so I let him know he's overdue. But the idea is, with him having that caregiver, I don't have to fly down to Florida every time he gets a sprain or a boo-boo or a fall down. I don't have to worry about too many things. I was there last year and he had some significant cough, which we were afraid would be pneumonia, and that caregiver was there pounding on his chest and doing whatever else she needed to do. Now, if I find out she pounds on his chest every day because she doesn't like him, well, and his back, not his chest. If I find she's doing that, I'll have to call the cops. But if she's pounding on the back to get the mucus out and all that, better her than me. And for those of you who haven't been through this, it's not a lot of fun changing your dad's dentures in the hospital and cleaning the polydent off, especially when he's messy. So let the caregiver do that. That's what they're there for. So the IADLs, which most people don't know about, are the instrumental activities of daily living. That is when the writing is on the wall that we're having a problem with your loved one. So some typical IADLs, the inability to balance a checkbook, not driving. I had a radio ad a few years ago, and I really think the announcer said, and mom's turkey just doesn't taste the same. So if there's an issue with cooking, if there's a problem with the checkbook, driving, the laundry isn't getting done, that's a sign that there's a problem in the works. The ADLs, again, are the activities of daily living: toileting, feeding, continence, bathing, and transferring, getting out of the bed to a chair or a chair to standing up. Those are your general 5 ADLs, and if you trigger 3 out of 5, you can then qualify medically for the veterans benefit and for Medicaid. Anyway, so we start off in the house, we have some issues with the IADLs, we're triggering some ADLs, then we're over in a retirement facility. Maybe we're looking at assisted living, nursing home, hospital, and then of course, rest in peace. We're all heading there. Hopefully there's some peace. So one of the problems that comes up is, what if we're too far to the left? What if we're home sweet home and medically, physically, we should be over at assisted living or a nursing home? So then what happens is, if you look at the top of the screen, we should be maybe in the middle here. Maybe we should be heading towards an assisted living, but we're still home. And then what that presents is what we call the zone of danger. And in that zone of danger, we have fall risks, malnutrition, and other problems. Now, if you want a visualization of caregiver burnout, our body is always going to the right, and the kids may be trying to keep you on the left. Maybe they don't want you, maybe you don't want to go in the assisted living, but you keep falling down and you keep having these problems, or your loved one does. So your body is pulling to the right. It needs to go to assisted living, but your family is keeping you on the left, and that back and forth is a rubber band where you keep going into the hospital and the doctors and falls and all these other things. If we look over here at another visualization of the elder care continuum, once again, we're going from the left to the right. We start off slouching a little bit. I started when I was 13. Then we have limited function. We've got a cane there. Then we have our walker, scooter, wheelchair, rest in peace. We're on the left. We're living at home. And then we got some help. And then we're in a retirement community, assisted living, nursing home, home sweet home. Rest in peace. Not home sweet home. That's the final home. The costs, they start off left. They're less. They go to the right. They're more expensive. The confusion, we have less confusion on the left. By the time we're on the right, we're a basket case. Now, if we're a 16-year-old kid who's going snowboarding and you fall and you break your leg, you're on the left of the screen, you break your leg, maybe you have a cane or a scooter or something, a wheelchair just to get around, and then you're going to pop right back to the left off the screen, back where you were. But when you're 70 or 80 years old, and let's say you're the top left of this one, where you have the slouch, and you fall and break your leg, well, maybe you're in a scooter or wheelchair for a while, and when you heal up, you're probably not going to be without that cane anymore. So the problem is, as we get older, we keep going to the right. That's the problem. Until rest in peace. Where you're going to be, you're going to stay at home, you're going to go into another facility. I mean, these are some of the things that we're looking at. With life care planning, we're just basically trying to make sense out of all this. We're dealing with transitional issues. We're helping the families out to make sure that they're getting the care they need, and we're trying to minimize the expenses involved in that. So I think it's about clear as mud. So that's life care planning. And what we try to do is make sense of the elder care confusion. And sometimes those puzzle pieces don't always fit together. But with life care planning, we're looking to put the elder first. And that's my suggestion to you as well. Someone calls us and what they're interested in is just saving money and not helping the elder, we'll wish them luck and, we'll look at them a little funny. But, when the kids come in and say, listen, we got to take care of mom and dad, if there's anything left over, that's gravy, but the money there is really for them, that's my kind of family. That's what we generally deal with. The elder care coordinator, as I was mentioning, the social worker, deals with these things that are on the slide. By the way, if anybody wants a copy of the presentation, if you reach out to Ed, we can see about getting that to you. And then I don't want to belabor the elder care coordinator, but we're not a car service. All right, so now let's go back to a couple of case studies. I think we have a couple of minutes, unless Ed, you wanted to chime in with a couple of questions. Otherwise, I'll hit a couple of these case studies a little bit.
No, go right ahead with the case studies.
Great. It makes it easier for you. You don't have to think of any
Absolutely.
questions. There you go. Yeah, I'm all for.
You covered all my questions.
There you go. Both of them. All right. So once again, the case study with Fred 80, Wilma 79, and we have he's a war veteran. So we said the military, dementia and confusion, difficulty getting out of bed and bathing. So the reason I said bed and bathing is that we're triggering some ADLs over there, activities of daily living. So getting out of bed is transferring. Bathing is, showering or bathing. So those are two ADLs right there. And I'll bet that he's got a couple more things going on. It's not too hard to find some additional ones. So with $1 million, he cannot get Medicaid because it's just too much money. So we can move money around. Now, Medicaid has a 5-year look-back period. So what are some of the things we could do? We could move the $1 million away and wait out the 5 years. And if he needs somebody coming into the house and they cost $3,000 or $4,000 a month, well, then you're going to have that kind of burn. He's got some income, so he'll have some money to pay for it. We'll look to the VA to help out and so forth. He's got $1,800 pension and Social Security. So if they have a $4,000 a month caregiver, they're going to be upside down $2,200, except the house may cost property taxes and utilities and all that. So anyway, we're going to look for the VA. We're going to look to protect as much of that $1 million as we can. We're also going to keep our eyes open in case we need assisted living help. And with assisted livings, they generally have a 2-year or so private pay, so we have to factor that in as well. Now, if Fred passed, Wilma's can only keep, before Wilma could keep $119,000 and Fred could keep $2,000 if we were getting Medicaid. With Fred gone, Wilma could only keep $2,000 and she has $100,000. So we have to look to dump $98,000, and there are some ways that we can do it. We'd still look for veterans benefits, but this time for the widow. If she gave away $50,000 2 years ago, we would then have a Medicaid penalty. If we want to burn out the Medicaid penalty, the absolute cheapest place we can do that is with the person at home. It is cheaper, less expensive for Wilma to pay for a home care agent for $4,000 a month than it is for her to pay $10,000 a month in a nursing home. So those are some things to think about. Giving $50,000, next slide, $50,000 to the family 2 years ago for college costs, doesn't matter. Medicaid says you had the money, big shot for college, you had the money to pay your health. So with $50,000 2 years ago, we might be looking at a 5-month or so Medicaid penalty. Covered Bridge is a housing development near me. The units go for $80,000 to $150,000. She has an income of $3,000 a month. In the old days, that $3,000 would have been too much for Medicaid anywhere but a nursing home. Now, with something called a Miller Trust, we can shelter that income. If she gave away the $50,000 7 years ago, it would be off the radar. It wouldn't matter. Ralph and Alice from New Jersey, 1 million non-qualified, 500 qualified. For those of you who don't know, and again, Ed is very good with this, qualified money is like IRAs. It's tax-deferred money. IRAs, 401ks. Non-qualified is everything else. So non-qualified is money you've paid tax on when you got it. Qualified money, you did not pay tax when it was deposited in that account. So if you take $1 out of an IRA, that is ordinary income. That's something to be aware of. So some major issues I see, they have a couple $1 million here. We know 1.35 is the estate tax threshold. So maybe the $1 million in life insurance needs to go in a trust. If they're in good health, can they get long-term care insurance? What do we do about that $500,000 qualified money? The house, what do we do with all this stuff? So, I mean, these are some issues. Maybe we move the assets away and cross our fingers and try to wait 5 years. There's different things that we can do, and it depends what they're looking to do. We talked about instrumental activities of daily living. So some of the mistakes are not being aware of that or of what's going on. And again, if you have trouble driving, the checkbook, the laundry, telephone. My wife, I think, has trouble with the laundry because all my whites come out looking pink. I have 3 daughters. I don't think I have a white anything left in the house. My socks, my dainties, we don't even have to get into it. It's a disaster. So she's got an IADL, but I think that's because she doesn't like doing laundry. One of the problems is not having the conversation when you need to. How do you get the car keys away from Dad, which is a near impossibility? Easiest way I found is his doctor has to do it. You tell Dad, stop driving, and he'll drive twice as much and, wherever you want. I think Yogi Berra said, if you don't know where you're going, you're not likely to get there, or you may get somewhere else or something like that. He had a few good ones. So anyway, you need to have a conversation when you have the problem. Some of the other biggest mistakes we see is failure to plan in general, and failure to plan with a qualified attorney is probably the biggest, most expensive mistake anyone can ever make in their lifetime. I know one attorney who described elder law planning or Medicaid planning as quicksand. If you make a mistake, it's really hard to get out of it. Speak to Ed, make sure your finances are squared away so that you have something to retire on. Maybe speak to us to make sure that there's something left over for that rainy day after that. And with that, I'm pretty much tapped out. That's what I had. That's all, folks. And thank you so much for listening. If anybody wants to chime in, or if you think people have had enough.
Do you have any questions, Ed?
No, I'm pretty good right now, thanks.
Gary, I want to throw out one question that I think is a good way to summarize the presentation, which I thought was excellent. And that is, how does a client, one of our clients, how does a person know it's time to see an elder care attorney as opposed to their family attorney who's been working with them for so many years?
Dave, thanks for that softball. I appreciate it. I take pride. I'm one of the few attorneys in the state who does not do real estate closings. We do literally hundreds of deeds a year for trusts, but we don't do a single real estate closing. And most families will use their real estate attorney for the will, a couple other things. You go through a divorce, maybe you'll use them for a will as well. For simple circumstances, that could be fine. The problem is when we're dealing with elder law, it's complicated stuff. And I've seen a lot of mistakes made by qualified attorneys, let alone by the guys who just don't do this on a daily basis. You do not want me to handle your bankruptcy. I'll end up getting you arrested. I don't know what I'm doing with bankruptcy. I know what I'm doing with this, though. These guys don't know elder law. They don't, and it's complicated. And with Medicaid, you hear about people worried that they're going to lose the house and all that. And the way we do it, that's never an issue. But if you don't disclose the assets, and then Medicaid finds out about them, that's called recovery. And New Jersey has the harshest, strictest in the nation. So you got to do this stuff right. Now, when do you know you need somebody for this? If you're thinking you need somebody for this. So as far as the elder goes, sometimes they'll come into my office and they'll say they're not sure why they're there. Ed said they need to see me. So they came, and I appreciate it. They paid a consult fee. Very nice of you. So what are your concerns? I don't know. And then we'll have to take them, well, are we going to go on the left or are we going to go on the right? Are we going to talk about estate preservation, saving assets, minimizing taxes, getting things down to the next generation? Well, that sounds pretty good. Are you concerned at all about the cost of long-term care if you get sick and have to go into a nursing home? And if someone leads off with that, that's what they're there for. I can't create that intent. And I was taught by a mentor years ago, you cannot create charitable intent. So if somebody doesn't want to give to charity, I'm not going to be able to talk them into it. Similarly, if somebody's not concerned about elder law and Medicaid planning, they're just not interested. Now, I can get a family in there that's 50 years old. Excuse me, I choke up over this. So I can get a family in there, and if they've seen other family members get wiped out by the cost of long-term care, the nursing home, they are motivated and they get it. And I have other families in there who think that these are white unicorns, never going to happen to them, and then they're not interested. And then what can happen, God forbid, I meet with them, maybe they only want to do simple wills or something like that, and then a year or two later, the wife will call me or the husband will call me that the other spouse is now sick, and suddenly they're a lot more interested. And the problem is, we could do a lot more when we have 5 years. That little snowball down the mountain becomes a giant snowball with the avalanche. If we have 5 years, we can protect everything. If we don't have 5 years, it's tougher. We generally charge more, and we don't get the same results. So we ask people to plan early. Vote early, vote often. So we want you to plan early. If any of this resonates, I think you need to take care of it. If not with me, I recommend with another certified elder law attorney. There's only about 43 in the state. And then if not, then go with somebody you trust. But you want somebody who really concentrates in this stuff. That's my opinion.
The other question I had is probably the most common technique I'll see people use, and it's very simplistic, is when mom or dad starts getting older, that they'll take their financial assets and start listing their son or daughter as a joint tenant.
Sure.
How effective is that?
I'm glad you asked. Thanks for softball number 2. I'm keeping track. It's about effective as I am in aerobics instruction. And for those of you who can't see me, you see Porky Pig on the screen? That's my thin cousin. So I am never going to be an aerobics instructor. We can agree on that. So what happens is, if we add somebody onto the account, we can have some gift tax issues, and we can have some easier estate administration, but even then not necessarily. But what happens is, New Jersey has the name on the check rule. So if mom or dad could pull the assets out of the account, whether they're competent or not, New Jersey says it's all theirs. Meaning, we have a $100,000 account. We have mom, dad, and now Junior is on it. That's not $33,000 each. That's $100,000 mom. That's $100,000 dad. That's $100,000 Junior. I say that's how New Jersey balances their budget. So the answer is it's not effective at all. But I do see that. Other things that I see are the poor man's will, where mom and dad are on the account and they name Junior as the beneficiary. Now, that will avoid going through probate, which in New Jersey is cheap and easy. I know lawyers who have been censured for talking about the high cost of probate. New Jersey, it's cheap and easy. We do run into those tax waiver issues, though. That's a problem. But if we did what I just described and we have Junior as the beneficiary, what happens if Junior has creditors after him? What if he's going through a divorce? What if he hit somebody with the car? So a trust can be superior to that. Similarly, if we add Junior to the account as a beneficiary, that doesn't take the account away from mom or dad. So if we need Medicaid a year or 5 years after we've put Junior on as a beneficiary, it's still their money. They're not going to get Medicaid with that money until we deal with it. Other things that I see are outright gifting. And some of the problems that come up is Junior may like that bottle a little bit, or he may like number 7 to show. So your money may be gone that way. Or you have 2 kids, you give $100,000 to each one of them, and you're broke now, and we're looking for Medicaid, and you need something that's $2,000. And child number 1 gives you $1,000 and says, "All right, sibling, time to give mom or dad the other $1,000." And then they say, "Who are you?" No speak of the English. So we have it in a trust format. We avoid those types of things. We also, frankly, keep the assets out of Junior's estate. So if Junior has a lot of money, or is a surgeon, or whatever the case would be, worried about lawsuits, worried about holding money from mom and dad, $500,000 or something, that could add to Junior's own estate tax and other issues. Same thing with other families with FAFSA for financial aid. So trusts are really good for helping out with all these circumstances. I don't know what I can add to it. I don't even remember the question.
Okay, I'll give you one more and see if we can get softball number 3.
No,
here.
my pleasure.
Okay.
By the way, when you buy 3, you get 1 free.
Okay, well, we'll just stick with the 3. One of the things I didn't hear you mention that I know comes up in the work that Ed and I do is the long-term care partnership programs in both New York and New Jersey, which I know are very different. Is that something that comes into play with the work that you're doing? Is that something that you recommend people pursue?
Great question. It's not coming up like it should. So again, I said white unicorn before. I've heard about these long-term care policies. I've yet to see one in life. You hear about them. And the way it works, as I understand, and again, that's why I think someone needs to see you or Ed to get squared away with this. And I'm personally indifferent if you get a partnership policy, a non-partnership, a this or that. Get something. Something is better than nothing. More is better, but then there's budgetary concerns and income and affordability. But it's my understanding in New Jersey and New York with the partnership policies, let's say I get a policy that has a $750,000 pool of benefit. What that means is I can keep $750,000 of assets beyond what I would have been allowed to keep otherwise, and I still get my long-term care insurance and I get Medicaid. So if I have a $750 partnership policy, I can go for Medicaid as a single person with $752,000 in the bank. Whereas without this type of policy, or if I just had a traditional long-term care policy and when I needed Medicaid, I'd be down to $2,000. Now, one of the other things what we didn't talk about, there are certain types of policies out there that I think are very good, but you may have a different viewpoint. And again, my viewpoint is get something. But there are certain policies that are single pay or 5 pay, 7 pay, where instead of paying year after year, and if you don't use it, it's gone, you can put money into it. You've freed up other resources because you don't have to worry about your medical expenses. And some of these policies will give you a death benefit if you die. If you don't like it, you can get your money back. And if you need it, then they'll erode the death benefit. So this way you're definitely getting value for the money you put in. So I think these are things that people need to explore. And you're better equipped than I am to determine what's the right thing for the family. But I think the important thing is that they take action and do something. More often than I like, I get the families in that say, we should have. Mom should have, dad should have 5 years ago, or whatever it is. And one of my favorite proverbs, Chinese proverb, the best time to plant a tree was 20 years ago. The next best time is today. And I say the best time to plan for Medicaid is 5 years ago, and the next best time is today. And with that, I think I'm tapped.
Gary, thank you. That was a tremendous presentation.
Thank you.
There was a lot of information. For those who are listening live, this is going to be up on our website, the recording of this, and you can go back in on the YouTube and listen on the YouTube, like the Google. Go back into the YouTube stream and control the speed so that you can listen to something over and over again until you get the information down. Gary, once again, thank you very much. It's been a great kickoff to our fall season.
My pleasure. Thank you. If anybody wants to call the office, I'll give a shameless plug if you don't mind.
Go right ahead.
Please give us a call at Garland Law Offices, 732-972-6700. We do have a toll-free number. I just don't know it. But, there you go. It's 844-442-6468. Even the call is free.
There you go.
Thanks so much.
And if anyone did not pick up on that, you're welcome to give us a call here in the office, and we of course have that information for you. This has been a great kickoff to our fall season. I want to remind everyone that we do these webinars live on the second Wednesday of every month. If you go to our website, you'll see the schedule of upcoming events. October 14th, we're going to have a great follow-up to this topic, which will be Medicare and supplemental insurance. November 11th, which is Veterans Day, we have a special for Veterans Day where we'll have a discussion on transitioning veterans, obstacles and opportunities, and what members of the community can be involved with veterans as well. And December 9th, we'll be talking about diabetes prevention, how to manage food and fitness to prevent the onset of diabetes. So it's a pretty exciting series of events we have coming up. I also want to announce that you'll be hearing more about on October 13th. We'll be doing a session in Red Bank on Social Security and healthcare costs and retirement. That will be a live presentation where you'll be able to come in for dinner and the presentation, and you should look for that flyer coming out very shortly. So with that in mind, I thank you all for attending today and look forward to seeing you in future webinars.